Serious violence was clearly your motivation. You arrived at the police station just before 7 p.m. After placing the rucksack on a wall, you started to remove items from it. You put a white cloth in a glass bottle, set light to the cloth, and then threw the bottle in the direction of a police van parked outside the police station just 2 metres from the entrance. The Molotov cocktail hit the ground in front of the van but did not ignite. You then took a further bottle from the rucksack and tried to set light to that. When that didn't work, you walked to the police van and poured the contents of the bottle behind the bonnet of the van before then setting light to the fluid. This caused a small flame to ignite under the bonnet. Tobacco tins were then taken from the rucksack. Those tins had burger fat and wood chippings. You'd prepared those items to be incendiary devices. You lit them and put them under the police van. Next, you used the knife to open 2 containers of lighter fluid. You then placed the knife behind your back, inside your belt, before going to the police van and placing the containers with lighter fluid under the bonnet. Count 1 covers your actions in seeking in various ways to set light to the police van, positioned as it was in the immediately outside the police station, were intended to bring about a confrontation with police officers and endanger the lives of those in the police station and any members of the public who may have passed the scene. Your efforts to set light to the police van failed. Using the adapted wooden pole, you struck and broke the windows of the police van. You also caused damage to another police vehicle. Police officers inside the police station became aware of what was going on and they confronted you. Police Constable Steph Fleming drew her taser. As the doors of the police station opened, you smashed the window of the police car with the pole that you had. PC Fleming shouted to you with her taser raised, "Right, put that down now." You continued to strike the police car. PC Fleming continued with her shouts to you and moved from the police station towards you, shouting, "Drop it, or I will taser you." You turned to face the officer and said, "I'm fed up and I'm done," whilst you advanced towards the officer with the wooden pole raised in your left hand. You made reference to the number 75. PC Fleming backed away and began to fire her taser, but it had no effect as you were wearing a bulletproof vest. Police Sergeant Coleman advanced towards you as you reached the threshold of the entrance to the police station. You then struck Police Sergeant Coleman forcibly with the wooden pole. P.S. Coleman produced his parva spray and ordered you to the ground. When you refused to comply, the officer deployed his parva spray. That had little impact on you. You called out, "Your government is vulnerable." It appears that you then went into the police station and swung the wooden pole at PC Coleman's head. You made contact with him and he stumbled. You then continued to try to assault P.S. Coleman by swinging the pole. You lost possession of it, but continued your assault using your hands. Detective Constable Emlyn then approached. You punched him to the left side of the head. He was then able to restrain you in a headlock, and other officers then assisted in restraining you. Whilst that was being done, you used the knife you had with you and stabbed Detective Constable Jack Cotton. He was stabbed to the inner thigh, narrowly missing the femoral artery. The wound estimated to be some 4 inches deep. Detective Constable Cotton's injury required stitches to the stab wound. He also had a graze to the forehead and another wound to his elbow. You made a further stabbing motion towards his chest, but thankfully other officers disarmed you before any further injury was caused. The attack on Detective Constable Cotton is the subject of count 2. Officers realised there was a fire burning under the police van. Police Sergeant Coleman managed to kick the cause of the fire away from the van, prevented the fire catching further. You were then arrested. On arrest, you said, "I've been damned since birth." Part of the incident captured on CCTV shown to the court in the course of this hearing. A police interview took place on the 1st of February. An appropriate adult was present. You declined legal assistance. It is clear your actions were deliberate. The reference to 75 was said to be your belief that Muslim grooming gangs had been operating since the 1950s. Expressed your intention during the incident was to let it be known that your tolerance for the government had come to an end by causing as much damage as possible. You said you teetered whether you wanted to kill someone and had not fully decided. You targeted the police as, in your words, the keystone of government power. You said you were opposed to what you said were the left-wing homogeny of British politics, and so that right-wing parties that rise up, such as the BNP, get shut down. You explained that a week before this you'd received a letter from the police in relation to providing samples connected to a public order offence. You were on bail for that matter at the time. You expected police officers to attend your home, and had they done so, you intended to attack them with a shovel that you had sharpened, and your intention was to kill any police officers who attended. In relation to the incident at the police station, your intention was to show as much damage as you could. In your words, I don't know whether I would intend to kill. I don't know. I didn't consider the scope of damage, merely that blood had to be spilled to make them bleed. I don't know if that answers your question. I know it's not detailed, but I didn't think I want to chop that person's head off and that person's foot off. I don't think in such detail. You spoke of wanting an outcome, again in your words, an acknowledgement that the functions of government on all sides have failed to uphold their duties in the state themselves, to protect our children, to enforce our borders, to uphold law and order, to ensure we don't get invaded, and acceptance that all of those have failed. You explained the preparation of various items you took with you, making sure the knife was sharp, that you had materials for making the Molotov cocktails, and obtained a bulletproof vest so as to prevent the police from disabling you with tasers. Since your arrest, there has been a close investigation into you and recent activity. A detailed schedule of events has been prepared and set out as part of this sentencing hearing. Of particular significance is a report to prevent, on the basis of racist and anti-Muslim views you hold, and the likelihood of being involved with incel groups. I note too various online activity which shows an increasing fixation on issues such as diversity, paedophilia, immigration, anti-Islamic sentiments, and dissatisfaction with the British government. Turning to victim impact, there are statements from a number of police officers. They speak of the shock of your actions on the 31st of January, that they are all experienced police officers, many with in excess of 10 years service as serving police officers. Whilst they accept potential violent and difficult confrontations are part of the role of being a police officer, they were all deeply shocked by the nature and ferocity of your attack on the police station, the vehicles, them as individual officers, and on their fellow officers. Some thought they were going to die as a result of what you had with you and what you were doing. Many speak of the anxiety, worry, and sleepless nights for them, their families that have followed your attack. Their families are proud, and rightly so, of the work they do as police officers to ensure the safety of us all. They and their families are very concerned going forward of any repetition of such violence they witnessed on this occasion. DC Jack Cotton was stabbed. He has 14 years of service and dealt with many violent incidents and individuals. He says the events on that night was something he'd never experienced before and that he will remember for the rest of his life. When he realised he'd been stabbed, he knew straight away from the location of the femoral artery the stab could be fatal. Believing it had missed the artery, he felt a sense of relief. He says that sense of relief was short-lived, as the medics dealing with him were concerned about the location of the wound. He underwent various assessments, thankfully only requiring stitches to close the wound. He knows the outcome of the incident, so far as he is concerned, could have been completely different and could have been fatal. As it was, he was unable to go to work for over a month. He was not able to care and play with his children as he would do normally. Whilst physical wounds may have healed, he speaks of the psychological impact of your actions. There is also a statement from the Chief Constable, Jeremy Vaughan, setting out the impact of your actions on his officers. As he sets out, the actions of all on the night were brave in undertaking the duties of a police officer. At the end of the statement, he says this: police officers serve and protect the communities of South Wales with courage, integrity and compassion on a daily basis, and I am immensely proud of the actions of those officers who apprehended Alex Dighton on the night. Their actions exemplified their professionalism and dedication in trying to save life, and in doing so putting their own lives at risk. They demonstrated sheer courage and determination, and their actions in reality, in really difficult and dangerous circumstances, prevented tragedy. I entirely agree with those comments, and in my view, all the officers involved here deserve commendation. You are 28 years of age, of previous good character. I have seen and read a psychiatric report from Dr. Shuja Riagu, dated the 16th of March, and a pre-sentence report dated the 9th of May 2025. Throughout these proceedings, you have not sought the assistance of any lawyers to represent you. At the hearings before this court, each stage of the proceedings has been explained to you, and you've been given the opportunity to obtain legal advice and representation. It is clear that you are aware of the inevitability that a lengthy custodial sentence is the only outcome in this case. I invited you to say anything you wish to say in mitigation. It is clear that you continue to hold entrenched views of the type you expressed back in January. Other than the early guilty pleas, there is little else to be said to your credit. You clearly engaged with the author of the pre-sentence report, and I will turn to the effect of that in a moment. Taking your actions on the 31st of January, together with the statements you made before the offences, as well as what you were to say in interview afterwards, I am entirely satisfied that all of the offences here have a terrorist connection. That is a statutory aggravating factor. In my judgment, the offences here were all aggravated by that determination. Turning next to the relevant sentencing guidelines and counts 1 and 2 in particular, where the maximum sentence is one of life imprisonment and attempted murder first as the lead offence. I need to consider whether you are dangerous. The test is whether I am of the opinion that there is a significant risk to members of the public of serious harm occasioned by the commission by you of further specified offences. Having considered all of the materials before me, in my view that test is clearly met here. I have regard to the offending, your comments before and since, alongside the contents of the reports that I have read. The author of the pre-sentence report notes your extreme mindset, that you are unapologetic for your actions, and that you display little or no sense of remorse. On page 9 of that report, the author refers to the fact that you've repeatedly expressed your intentions to cause further serious harm on release. On pages 12 and 13, the author identifies a number of factors relevant to the issue of dangerousness. Of those, I identify and make comment on the following. Firstly, and to quote from the report, in terms of the potential for future harm, there's been no shift in Mr. Dighton's attitudes since his arrest. He holds a somewhat cavalier attitude to this offending, and he expresses no remorse. Secondly, whilst his behaviour in custody appears to be settled, there have been ongoing concerns raised in respect of his comments to other prisoners. Thirdly, Mr. Dighton is neurodiverse, diagnosed with mood disorder, which may make him susceptible to the influence of others. Whilst he does not appear to have been experiencing any significant symptoms at the time of the offences, Dr. Riagu has noted that Mr. Dighton's symptoms will return at some point and will require management. The concern is that he is currently not willing to access mental health support, therefore it's difficult to formulate any understanding of factors that would indicate when his mental health is deteriorating. Fourthly, Mr. Dighton does not believe he poses a risk to the public. However, he asserts that anyone working for the public, including police and probation staff, would be legitimate targets. Fifthly, Mr. Dighton remains rigid in his thinking and asserts he, to quote you, 100% will do the same thing if the government does not change. The next matter I need to consider by reference to Section 285 of the Sentencing Act 2020 is whether the offence of attempted murder and the other offences associated with it, in particular the arson and the other offences of violence, is such as to justify the imposition of a sentence for life. If the answer to that is yes, then a life sentence must be imposed. On the offence-specific guidelines for attempted murder, in relation to culpability, you went to the police station intent on serious violence, having undertaken significant planning and preparation. There are two characteristics that point to this case being one that comes within very high culpability. I quote, attempted murder of a police officer, and secondly, offence committed for the purpose of advancing a political, religious, racial or ideological cause. Within category B1, I note the offender took a knife or other weapon to the scene, intending to commit any offence or have it available for use as a weapon, and used that knife or other weapon in committing the offence. Whilst I acknowledge the contents of the interview with the police, as well as the psychiatric report, in my judgment, this is not a case that would come within categories C or D. In my judgment, this is a case to be dealt with within very high culpability. On harm, this is within category 2, serious physical or psychological harm, not in category 1. For category A2, the guidelines provide a starting point of 30 years imprisonment and a category range of 25 to 35 years imprisonment. In terms of statutory aggravating factors, you were on bail at the time in relation to a public order offence. In addition, the offence is aggravated by the other offences on the indictment. Of particular note is the offence of arson, the attempted grievous bodily harm, threats and battery, with the various weapons you had. On mitigating factors that apply, you have no previous convictions. I note the contents of the psychiatric report and the pre-sentence report about your mental state and background. Much of this is in the form of self-reporting by you to the interviewer. It is important I note what is said, but in my judgment, there is a limited impact in terms of mitigation of any sentence that would otherwise be appropriate. Before allowing credit for plea, taking into account the aggravating factors and in particular the other offences, a sentence just above the category range as one of 36 years would be appropriate. Then allowing for the mitigating factors produces a sentence of 33 years imprisonment. You pleaded guilty to all matters and are entitled to full credit of 1/3, so that would reduce the sentence to one of 22 years. As I indicated earlier, I do find the test for dangerousness to be met. Having regard to Section 285 of the Sentencing Act 2020, taking the offence of attempted murder and the other offences associated with it, in particular the arson and the other offences of violence, in my judgment, this is a case such as to justify the imposition of a sentence for life. For all of the reasons I've identified in the offences and in your approach to them, such an approach is justified. Having come to that conclusion, a life sentence has to be imposed. In coming to that decision, I should also say that I note what is set out in paragraph 22 of the judgment of the then Lord Chief Justice in the case of the King against Berkinsas and others in relation to discretionary life sentences. I need to consider the seriousness of the offence and any previous convictions, and of course here there are none, but I need to consider the level of danger you pose to the public and available alternative sentences. On count 2, there will be a sentence of life imprisonment with a minimum term of 22 years. As there is now no early release for terrorist offenders or those who commit offences with a terrorist nature, the minimum term is the same as that as the determinate term. The days on remand, which I'm told number 130 days, will count towards that sentence. And so the sentence of the court on count 2 is one of imprisonment for life with a minimum term of 21 years, 235 days. What it means is this, that before you will be first considered for parole, there will be that period of 21 years and 235 days. If the information which I've been provided to us, the days on remand proves to be inaccurate, then the prosecution must notify the court so that the case can be relisted to correct the calculation as soon as possible and in any event within 56 days. When it comes to the minimum term that you will serve, I make plain that I'm not ordering that you are to be released at the end of it. Whether you'll be released or not at that stage will be a matter for the parole board to consider. Only when the minimum term has been served can the parole board decide whether it is safe to release you or not. If the board does not release you, if the board does release you, rather, you'll remain on licence and liable to recall for the rest of your life. On count 1, that's the attempted arson with intent, a sentence of 3 years imprisonment. On count 4, attempted grievous bodily harm, 3 years imprisonment. Count 5, threatening with an offensive weapon, 18 months imprisonment. Count 6, battery, 8 months imprisonment. Count 7, 18 months imprisonment. Counts 8 and 9, 18 months imprisonment on each. And on counts 10 and 11, 3 months imprisonment on each. Those sentences to be concurrent to each other and concurrent to the life sentence that I've imposed on count 2. In the light of my determination the offences have a terrorist connection, you will be subject to automatic imposition of the terrorist notification requirements under Part 4 of the Counter-Terrorism Act 2008. Those notification requirements will apply for 30 years. Under Section 23 of the Terrorism Act 2000, I order the forfeiture of the knife, the hatchet, the wooden pole, as well as other items in your possession or under your control at the time of the offences. Finally, if the statutory surcharge applies to your case, the appropriate order may be drawn